The Supreme Court made a very important decision in April of 2024 in a very important case, but many lawyers and employers are not getting the message and they're going about it as business as usual. So I'm Trang Tran, your labor and employment lawyer friend, and I'm going to break it down for you so you're not misled or there's any misunderstanding about what the law requires. The lawsuit was brought by Sergeant Modrow versus the city of St. Louis, Missouri. She was a police officer in the intelligence department, and when a new supervisor came in, she was removed and transferred to a new department and replaced with a male police officer. After she was transferred out of this department, she sued for discrimination based on this transfer. The city, the police department, fought the discrimination lawsuit because they felt that the transfer itself is not discrimination. So this case went all the way up to the Supreme Court because of the word harm. The employer said that the plaintiff has to prove significant harm. And before the Supreme Court was, what does harm mean? Does it require the word significant or just anything, harm itself? So here's the harm in this case. When she was transferred, she lost her take-home car. She lost the opportunity to do investigative work and to network with supervisors, and it was less prestigious being moved from investigation, intelligence, to a new transfer position that was new. Now, employers often do this. If they can't win on the facts, they will try to fight on the standard, the metrics to be used. And so they're injecting the term significant harm. So a plaintiff would have to prove significant harm according to the city of Missouri. And the Supreme Court say, no, that's not true. All you have to prove is harm. And what does harm mean is still up for determination on a case-by-case basis by other courts in the future. But the Supreme Court says that you don't have to prove the word significant harm, which raises the bar from any harm to whether or not it's significant. And many employers are still reading it wrong because they're reading old case law and they're not reading the actual statute. So this is a little friction between case-made law versus statutory law. The statute may be written certain ways, and judges over the years may add additional terms or requirements. And that's not really the law, it's what the Supreme Court just said. So keep that in mind when you're facing discrimination. All right, back to work.